Yes, good evening to everybody. That yes, morning that I half of it I taught that is a trespass to the person where we did it a little bit assault, battery, and false imprisonment. And read what I posted on the screen. Anyone can unmute and read.
Good evening, sir. Private property, no trespassing. Professor Dr. Mohammed Saheb Hussain, sir.
Yes. So trespass means illegally entering into somebody premises is called trespass to land. Stealing some property from there is called trespass to goods, and beating him and causing the reasonable apprehension to him or detaining without legal justification, that is called trespass to person, namely assault, battery, and false imprisonment. So let us see that we completed up to the statutory authority in the morning, in the afternoon session, that is from 3:10 to 4 o'clock. And today's session that we will try to complete the trespass to persons, where we have touched a little bit that thing, trespass to persons, trespass to property that we will see it. Yeah, trespass to against the property. Trespass against the mobile property like goods, that's called trespass to goods. It is a taking wrongfully or forcefully interfering with the goods of another. It differs from the trespass to land in one important aspect, that the wrongful intention or negligence is not necessary for the trespass to goods. So, trespass to goods, wrongful intention or the negligence is not necessary. A challenge to ownership of the goods amount to conversion, which is different from the trespass to goods, which can be elucidated by an example of the damage of goods given by the plaintiff in a cloakroom of railway, but personal, there's instead of giving it through it and damage it. What is the cloakroom? An idea? CLOAK, cloakroom. Yes. If you have an idea, please tell me what is meant by cloakroom.
Storage room, sir.
Yes.
I think it is storage room, sir.
It is a storage room at the platform, railway platform. Mostly they use the word cloakroom because
Yes,
the
sir.
passengers is having a lot of luggage. So if they want to just make the round trip to the Agra or Fatehpur Sikri, then they will keep their the big luggage in the clock room. Of course, they say everything should be locked. Then they will give the receipt. Then they can say that Raj Mahal and Fatehpur Sikri, Buland Darwaza, they could see it and then come back and take the goods from their luggage from the clock room, then will they board the next train or the connecting train. So if you keep the in the clock room, suppose somebody is damaged over there, then we can file it in the form of the bailment or in the form of the conversion. So these are all the offenses they did it. So trespass against the immovable property like land, so the illegal maxim is there. Quare classum frigit defines a land as a land includes not only the surface and any buildings on it, but also the airspace and subsoil. So when you say the quare classum frigate defines, land means that includes not only the surface space, but the beneath the land and above the land also that belongs to the owner of the property. Insofar as these are vested on the plaintiff, the action of trespass to land, penalizing the direct interference with the other people's land. So if you're having the land, that means somebody should not enter into a land without your permission. Neither you should enter into the land, encroach on the land of another, unless until you take their permission. So that is a very much important factor. Otherwise, you will be called as a trespasser. Trespass is mainly a wrong against the possession and is available at times against the owner himself. Court in the case opined that the correct position in the law may, in our opinion, be slated that in order to establish that the entry on the property was with the intent to annoy, intimidate, or insult. It is necessary for the court to be satisfied that the causing such a annoyance, intimidation, or insult was the aim of the entry, and that it is not the sufficient for the purpose of show, merely that the natural consequences of the every entry was likely to be annoyance, intimidation, or insult, and that is likely to consequence was known to the person entering it. That in deciding whether the aim of the entry was the causing of such annoyance or intimidation or the insult, the court has to consider all the relevant circumstances, including the presence of the knowledge that is the natural consequences would be such annoyance, intimidation, or insult, and including also the probability or something else than the causing of such intimidation, insult, or annoyance being the dominant intention which prompted the entry. Suppose if you want to enjoy your land, yes, you do have the every right to enjoy the land, but you should not cause any nuisance to the other people when you are enjoying your land. That means, in other words, you are interfering with the peace of that people and making them annoyance for that people. And sometimes you make the intimidation also, including the insult also to the people, then you have committed a mistake or an offense. So no one has the right to dispose the trespasser if he is a settled possession of the property, and he can't be evicted unless the process of law is followed. Suppose if you are the owner of the property, that means the ownership would be with you and you are the possession of the property also. At that instance, no one can deprive of your ownership. The position in which a trespasser is entitled to define against the rightful owner must be settled position extending over the sufficiently long period and acquiesced in by the true owner. Because generally in the common law that we will say possession is a 99% ownership. So generally a person who is the owner, he should be in the possession of that property. In case if the possession of the property, but the property belongs to somebody else, yes, at the time occupier's liability would come into the picture. Then who is the occupier at that place, and who is the responsible if any injury is caused to the person. So we have the case law, what I said yesterday, the springboard case law, occupier's liability. And it also said as a extreme, that is actio personalis maritem cum persona. Then also will be used at the absolute liability. What is that name of the case law? Anyone? Unmute and give me the answer. Diving board, I said. Swimming pool, I said.
Class Metal Bachad versus East India Hotels.
Class Metal Bachad versus East India Hotels Limited. That is the case law. So, under the doctrine of the prescriptive easement, for example, a property owner loses the absolute right to exclude all other person from taking the possession of his land when a non-owner has used that land openly, peacefully, continuously under the claim right adverse to the owner of the period is set forth by the particular state known as the prescription period. And generally, the prescription period, some places, the 20 years would be there. If you used to stay in a particular place for the more than 20 years would be there. So the law of doctrine of prescription will prevail over there. That means we are the owner of the property because we enjoy the property without the disturbance of anyone. Even though whether you are a owner of it, whether you are a possessor of it, it is a different issue. But if you enjoy the property more than 20 years over there, then the law of prescription will be applicable over there. Then generally you will be deemed to be the owner of the property, or if the presumption is that you are the owner of the property. It was held by the High Court of the Bombay in case that a rightful owner who disposes the another can't be treated as a trespasser except as provided by Section 9 of the Special Relief Act, 1897. Is it? What is that? 87 or 1876? What is the Specific Relief Act?
1876, I think so, sir.
1876 to my knowledge also. But let us check it. Why we should have to just fire it. Yeah. Channel is there. Okay. It's asking for the one. Okay. Let me see that which one is the right. Specific Relief Act. It is a Specific Relief Act of 1877, not 1876. It is in 1877. So, what is the purpose of the Specific Relief Act? Anyone?
Pass on, sir.
See, when the contract is made over there, if any person made a breach of contract, At that instance, the other party will say that, no, we don't want to accept the compensation or violate the breach amounts, but we want the contract should be specifically performed. For instance, a land is there which is adjacent to the shore. A good demand would be there to make that area as a beach. At that instance, he said, I don't want the money. Or I will pay the twice or thrice. No, I want the specific performance should be done. That means you have to hand over the land to me and I will hand over the money to you. So the purpose of specific performance is the specific performance of act of course, this is another act, but doesn't matter. Set out the remedies available to the parties whose contractual or civil rights have been hampered. They don't want any compensation. They don't want any monetary compensation, but they want that the contract should be performed. The act comes into the play where an actual damage for non-performance of a contractual obligation cannot be measured or monetary compensation would not suffice. So when the monetary compensation is not sufficient to it, they want that a specific performance should be done to the contract. So that is the purpose of the specific performance of 1877. Okay. Now let us see some of the case law. Santini
Okay.
Ceramica Private Limited versus Kunchi Krishna Mohan and others. Kunchi Krishna, Kunchi Krishna. Statutory authority search and seizure on the premises of appellant don't constitute an act of trespass. If the warranty would be there, so a policeman having a warranty could enter into somebody's premises and he need not to ask the permission because he is having the warrant. But nominally say I have the warrant, then you should have to allow him to get inside to check what the purpose of his warranty is there. It cannot be said that any procedure carried out to find the truth and the property will be constituted to be an act of trespass if the act is carried out with a sufficient legal backing. So, if the sufficient legal backing for an act is done, then we say it is constituted in a good manner and there is no exception to it. So, all the penal statutes should be constituted very strictly. That is the main idea. So, Amit Kapoor versus Ramesh Chandra and another, merely because there was a civil transaction between the parties, it would not by itself alter the status of the allegations constituting the criminal offense. Suppose if that only a civil transaction between the parties, so generally it will not be by itself alter the status of the allegation constitute the criminal offense. If the offense is a civil offense, then it will be civil action will be taken. But then an offense is both the civil and as well as the criminal offense, then the two actions will be run parallelly. The criminal offense will be moved by? Yes.
CRPC.
The criminal offense moved by the state. Of course, the procedure should be followed in the CRPC. Okay, now Samira Kohli versus Dr. Prabha Manchandan and others. The case law is the performance of the hysterectomy and sublingual operectomy. These are all cuttings. Rectomy, cuttings only. Hysterectomy and sublingual oophorectomy, and a patient was an unauthorized invasion on her person by the doctor, it can be reduced to be an assault and a constitutional battery also. Her consent was required as she was an adult, and although the doctor acted in the best of patient's interest and can be considered to be the mitigating circumstances to reduce the compensation. However, in the interest of the justice, the patient is entitled to the compensation. Suppose if nothing would be happened over there, then how the patient died? Means something will be happened over there. Either in the process of conducting the operation or the tooth may not be sterilized properly. So any one of it, if the patient is kicked to the bed, that means operation succeeded, but the patient died. That is the meaning. So let us see the Rajendra Kumar Malhotra versus Indian Bank and others. The petitioners for a license to operate the kiosk through the action. What is kiosk? A champagne shop. A Assam provisional shop is called kiosk through the auction. And the right was taken away by the government corporation after the revocation of license and the expiry of the license period. Of course, the license period will be there. If it is expired over there, then the new license you have to pay it. You have to pay it and the revenue also, because that's the way the government will get the revenue in the form of license by taking the money. So here the court made the distinction between the license and the lease and held that the license does not create a position and it is the discretion of the authority to revoke the license and disposes the petitioner if any irregularity or discretionary act guides them to do so. So a lease creates a possessory, inviolable, and settled right on the person to whom it is granted, just generally. Whereas the license has a different footing altogether. A leased property cannot be trespassed on without the lawful justification and exhaustion of the public need. On the other hand, a license neither creates the ownership nor a possession of rights in favor of the person to whom it is granted. As a result, it cannot be said that the petitioner's right has been trampled upon by trespassing on the property. I don't think that such a thing is happening over here. Okay, read the section 9.
Section 9 of the Specific Relief Act protects the possession of the tenant from the deprivation by the owner even after the cessation of tenancy. However, there needs to be settled possession in it of the tenant, and this possession is judicial and is protected by statute.
Yes, this section 9 clearly makes the Specific Relief Act of 1877 protects the possession of the tenant from the deprivation by the owner. So generally the owners will make it out. So whenever they got fire, then they will say hire and fire would be there. They got the fear, not the fear, they got the, what I say, anger. That is the more appropriate word. Then it is the only the tenant will be the victim. At that instance, Section 9 gives given certain powers. They cannot, a landlord cannot act with his whims and fancies because a contract should be made. In every contract, there will be a provision will be there. When the contract renews, then this much percentage should be increased. Or to the 2 to 3 years, the percentage of it should not be increased. So such a contract terms would be there, then only it can be done. Otherwise, the section 9 would be applicable. But here is a Bhavisetti Venkata Surya Rao versus Nandipati Muttaya. This is the case law. I repeat, Bhavisetti Venkata Surya Rao versus Nandipati Muttaya. Actually, we have to pay the revenue to the revenue department for the either having the land or some other thing. So some part of the levy would be there and that should be paid to the government. So there is the last date would be there, and the farmer wife, she went for the casual labor by locking the house. And if they go in the morning, they will come back only in the evening after the work is over. So the defendant, in order to collect the amount through the visit of the plaintiff's house, and he came and asked, yes, by the time the house is locked and only essential things which are used for the agriculture will be only outside. But such a thing, they cannot attach it like a plow. A farmer, you cannot attach it because that is an instrument where he could have his livelihood. So, and such thing cannot be attached. Then they checked everything, but they did not find any other material or mobile or immovable property here and there. Then they found this man is having a gold earring. Of course, some people will make the male, make the gold even nose ring or preferably the earring. They will use it. Do you know why the male use the earring? Gold earring?
Fashion.
Nowadays it's the fashion, but at the time the woman is there. Suppose that every boy is going to die. At the time they will say that okay, instead of boy they will make it a earrings. They will say that she is a female. So at least by the way she will be survived. So that the woman would be there. A muda namakam. Are you following me?
Okay, sir.
Yes, sir.
So that is the reason they will make it out. Even mukuda kudtaru. Even they will make the nose as well as the ears, because they want to see that she is it is she want to represent, because he every time they are dying in the when the childhood only or at the time of the delivery. So the people who used to do. But this man is having the gold earring, and then they want to clear off by this gold earring. So they call the goldsmith to remove the earring. But by the time some good Samaritan would be there, why do you want to remove the earring of him? And because it is a good omen to him, okay, I will pay the revenue, whatever the due is there. So he paid it, and the matter is resolved. But the plaintiff, he felt insulted, annoyed, and he felt guilty in the presence of everybody. They want to remove my earring or nose ring. So, but actually the goldsmith came, but he did not do anything to remove this earring or the gold ring. So here he signed a case against the, they made the assault on him as well as the battery. But there will not be any assault, as well there is not any battery at all. Merely they called the goldsmith, but the goldsmith did not come and try to make the trial to remove the gold ring from the ear or from the nose of the plaintiff. Is it clear?
Yes, sir.
Yes, sir.
So the arrival of the goldsmith said nothing and did nothing, and the threat used of the force by the goldsmith to the plaintiff was too remote possibility to have put the plaintiff in fear of the immediate or instant violence. There was no assault. Let us see the another English case law, Bird versus Jones case law. The claimant was trying to go through the enclosure, but the defendant put two police officers to block the claimant's path and prevent him from the entering further into the field. He was told that he could go back, but not forward. After half an hour, the claimant tried to push past, whereupon he committed an assault on the defendant and was arrested. So there is no thoroughfare. There is no other go. You are not supposed to use that path. So the policeman is launched over there. At the time, you are not supposed to push them and go inside. Otherwise, you will be called as a trespasser. So here, and they will take an legal action against you. Even they can arrest you, and they will keep a section in such a way that you will not be get on bail also. Are you following me? Yes.
Yes, sir.
Yes,
So
sir.
Bird versus Jones, here also, they did not touch it, but he stood just like a pillar or a wall. But he did not make it out. That doesn't amount to the arrest or assault or a legal confinement to him. But the one way is not allowed, but the other ways are allowed to move. The court said that it is a false imprisonment for a person to be forced to stay in a place just as much as locking them in a room. So there's a false confinement, I said, when totally confined he is. There need to be any touching either. However, it cannot be a false imprisonment to avoid the person from going forward, but allowing them to return the way they came, even it is unlawful to stop them. If he is having a legal right would be there, that it is unlawful to stop him. So that is a very much obvious factor. The person, no doubt, suffers a wrong, but not false imprisonment. Possibly assault or battery if he is endangered or touched as he tries to get past. So here it was held that there was no wrongful restraint or confinement, because he will be allowed to the other direction, but only one direction they are not allowed over there because certain sanctions are there. So that is the way we can make it out. So Reed versus Cooker, this is another case law where D means defendant and his men surrounded P means plaintiff, rolling up their leaves and threatened to break P's neck if he did not leave. P was a rent collector who entered the D's workshop and refused to go until the rent was paid. So it was held that this was an assault. The condition attached to the threat was not enough to nullify it. So suppose if you are rent, we are supposed to pay it, then naturally he will not leave it unless until that you pay the rent to him. Am I right?
Yes, sir.
But a person wants to make it out, అరే రా 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 అని స్లీవ్స్ పైకి లేపుతారు. స్లీవ్స్ పైకి ఎందుకు లేపాలండి?
కండలు చూపించి కొట్టడానికి సార్.
టు మేక్ ద హ్యాండ్ ఫ్రీ. అచ్చా, వాచ్ తీసి పక్కకి వాళ్ళకి ఇస్తారు. ఎందుకు ఇస్తారండి?
వాచ్ పగిలిపోద్దని సార్.
So these are the things generally they will make it out when before they are want to attack somebody else. Or వాడు ఏం చేస్తాడు, బెల్ట్ కూడా తీస్తాడండి. because he used the belt as a lash to lash him from the distance. So it was held that this was an assault. If they could do so, and it is amount to assault, and attached to the threat was not a cart to nullify it. But assault, there should be the immediate threat should also be there. The condition attached to the threat was not enough to nullify it. So if there is no threat would be there, then it is not amount to assault. If there is no knowledge of the threat is there, you will not able to assault. Like I shown you, if you want to punch from the behind your head, you could not see it, then you did not have a reasonable apprehension in your head, and you cannot jerk it also. Is it correct?
Yes, sir.
Then conclusion, trespass can be faced with the people innumerable times in a day. But what is important to truly understand the nature of the trespass act or property, loss, and impact of it on the plaintiff. If the nature of the act itself is suggestive of a wrongful incident, voluntary, and taken to constrain the enjoyment of the right to exclude from the private property. So if you want to enjoy your own right, okay, the private person should not interfere in your affair. So that is what I want to convey to you. So exclude from the private property, then evaluation of all possible recourse to the recoup the damage and should be identified. The 4 tests are there. What are they? When read it.
When
What are the
deciding
4?
trespass disputes, courts should evaluate the following factors. Number 1, the nature and character of the trespass. Number 2, the nature of the protected property. Number 3, the amount and sustainability of the trespass. And number 4, the impact of the trespass on the owner's property interest.
Yes, these are the 4 tests you have to make it out to see the nature and the character of trespass. Whether the trespass he made it, is it to protect his life because a cheetah is behind him, a leopard is behind him? If it is so, it is a necessity, it's not able to trespass. Then number 2, the nature of the protected property. What type of the property that you would like to protect it? It is a very much costly property. Yes, you have to have having the every right to protect it. But it's a very light property where you are using the forces more than what is required over there, then naturally that you have committed an offense. It is not the nature of the protected property. And the third, the amount and substantiality of the trespass. Now the amount which are giving over there is a meager amount, but this time they say either he put it behind the bar if he is in case of the default, and if he pays over there, okay, this much 1,000 rupees will be paid to the victim. Okay, if that can be done. Suppose if they breach it, then they will the lady will file a case against him, and such warrant would be issued when the summons are served where he did not attend the summons day. So it would be better. It would help to uncover the various facets and understand the dimensions that trespass law is clutching in its circuitous surroundings so as to loosen the screws and solve the cases and situations in an efficacious manner. The true meaning of each term needs to be understood to evaluate the trespass and resolve the case by applying the relevant doctrines. So this is the few of the cases, and what we decided. But some of the cases which is not mentioned here also could be mentioned because it will give the sense to you that you will understand the total concept of it, and you have cited which is favorable to you and which is not favorable to you, both the way that you defined it. Hence, more justification will be there. At that instance, you will get the more marks. Am I right?
Yes, sir.
So, whenever your answer should be according to the length of the answer sheet. Are you following me?
Yes, sir.
So these are the certain things which I would like to share, but let us see what is there in the syllabus extra which is given and which we are not studied. So syllabus, yes, here it is here. The rule versus real and fracture. Where you are searching the right direction. Yes, it is there. So if you happen to see the syllabus, you can come as extinction of the liability that we already cover over there, and the specific tort starts affecting a person, that is assault, battery, and false imprisonment. Then will come the malicious prosecution, you will see it. But in that, again, the nervous shock will come. What is the case law I told you in the nervous shock? Anyone? In the morning also I discussed the nervous shock case law, making a practical joke that your husband met with an accident where your 2 legs are amputated. Now he's taking rest in the hospital.
Wilkinson versus Downtown.
Wilkinson versus Downtown. That is the case law which can be used over there. Then now the question comes is only we have to deal tomorrow class, but tomorrow is a Sunday, and in the Sunday, because where I worked earlier in one of the college, they want to felicitate all the teaching staff, those who taught to them tomorrow. So tomorrow there will not be any class, but tomorrow class I may compensate at any day of the Monday or Tuesday, but I will inform in advance. But before you are coming to the class, online class, what you have to read?
Malicious prosecution.
Malicious prosecution, that you have to read it. Later on that we will see the nervous shock. Okay?
Okay, sir.
Yeah, that is the thing which
Yes,
I want
sir.
to share with you. And this is also a trespass. Private property, no trespassing. Did you see such a caution board?
Yes, sir. I have seen in my childhood.
Okay, but nowadays nobody is keeping such a thing.
They are keeping this land belongs to this person. That's
Yeah,
that
they
much.
say this land belongs to so and so person. If anybody crosses it, he will be prosecuted. If anybody jumps over it, then he will be prosecuted. Or if anybody enter in it, then he will be prosecuted. That wording should be there. So with this, I would like to wind up today's class, and tomorrow when you come, tomorrow means whenever I take the next class, the malicious prosecution, we will read it and we will make the class as a participatory class. With this, I will stop my sharing. Have a good day. Bye. End of the meeting for all.
Thank you, sir.
Yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.